from the station that's on your side. This is Channel 7 News at 10.
Well, good evening to you. Tonight, the Arkansas Secretary of State says that he will comply with the Supreme Court decision ordering an immediate count of some of the signatures that were gathered to place an abortion amendment on the November ballot. But the fate of that proposal itself is far from settled. Channel 7's Emma Allen has been digging into this story throughout the day. She joins us live in our studio now with what she's learned. Emma?
Good evening, Chris. This has been unfolding since the signatures were turned in on July 5th. The proposed amendment would prevent the state from restricting access to abortion up to 18 weeks after conception. It would also allow for abortions after 18 weeks in the case of rape, incest, fatal fetal anomaly, or to save the life of the mother. Arkansans for Limited Government say they just wanted an initial count. But another group, one who does not support the ballot initiative, says if Arkansans for Limited Government did not follow the proper steps, their ballot measure might be dead.
I find it interesting that the backers of the other petition measures that are vying for the ballot did do all their paperwork properly on their paid canvassers, but this abortion group did not. So apparently the rules were clear enough to other participants in this, but for whatever reason, this group just failed to do so.
Jerry Cox, Executive Director of Family Council Action Committee, said if Arkansans for Limited Government falls short of getting the initiative on the ballot, there's very little the group could do.
Because the law is so clear in saying if you fail the initial count, if you don't get the minimum number required by law, then you don't get a cure period and your measure is basically dead.
But Rebecca Bobrow, the Director of Strategy with Arkansans for Limited Government, said they are still hanging on because now the Supreme Court instructed the Secretary of State to perform an initial count on the abortion ballot initiative signatures collected by volunteer canvassers for the organization Arkansans for Limited Government no later than Monday.
The Supreme Court ruled in AFLG's favor on a few issues, and they did not rule in the Secretary of State's favor on any issue.
Bobrow calls this a win for democracy.
A win for the 800 volunteers who were out across the state collecting signatures, and a win for the 101,000 Arkansas voters who signed their name to a petition.
KATV spoke with a pre-law professor at the University of Central Arkansas, Bailey Fairbanks, who told us there was still some legal uncertainty about if the initiative will land on the ballots.
Is only partially settled. Of course, we know that they are going to do the signature count for the volunteer signatures, but there is still the debate, of course, with the canvassing signatures from the paid canvassers that are a big question. And of course, just generally, right, the filing issues with the paperwork.
If you remember, 2 weeks ago, Thurston rejected the Arkansas abortion amendment, citing the group's failure to properly identify its paid canvassers or prove that they had been properly trained as required by law. Thurston also said the proper paperwork wasn't turned in with the signatures and estimated that only around 87,000 signatures would count, which would mean they are just a little over 3,000 signatures short to get on the ballot. But now the court has ordered to get an exact number.
Once that's done, we will know if they reached the threshold of 90,704, which is the minimum number that they need in order to move forward in the verification process.
If there are enough verified signatures, the Supreme Court says this could be enough to get a 30-day cure period. On your side, I'm Emma Allen.
Okay, Emma, we know you'll be watching. Thanks. Again, this initial count of signatures gathered by volunteer canvassers is now underway. The court has told the Secretary of State it should be completed no later than Monday.